The Law and Economics Podcast is a production of the Journal of Law, Economics, and Policy at George Mason University School of Law.
I'd like to introduce Gavin Young, our moderator for the evening, counsel for the Senate Judiciary Committee. This event will be recorded and available later for audio and visual listening on iTunes, so if anyone's interested, then later you can pass this along to anyone else. Without further ado, I'm going to turn this over to Gavin so he can introduce the panelists, and then we can get started with a lecture entitled Federal Banking Regulations Force Online Casinos to Fold.
Thanks, Amanda. Thanks to JLUB and also to the distinguished panelists for taking the time to put on, I think, a very fruitful discussion on something that's very timely. And I first want to preface this by qualifying that, although I do work for the Senate Judiciary Committee, things I say here, should they be an opinion, do not necessarily reflect those of either Senator Arlen Specter or other members of the Senate Judiciary Committee. Also, as an aside, I also want to make clear I was not directly involved in the passage of the legislation that's in question today, so please don't blame me. A little over a month ago, on September 30th, President Bush signed in the Security and Accountability for Every Port Act of 2006, or also known as the Safe Port Act. Signed that into law, and the last title of this law was the Unlawful Internet Gambling Enforcement Regulation Act of 2006, which many of you have probably read about a little bit in the newspapers. After this bill was signed, it generated almost immediate results and some speculate far-reaching results, but I guess that's a question that we're going to be trying to answer today. This bill, in various forms, was basically the culmination of about 8 years of effort and experience, probably beginning, I think, with its first introduction by Senator Kyle back in the 105th Congress. It's also in response to findings by a commission entitled the National Gambling Impact Study, and they were commissioned to basically generate a report back in the late 90s to basically explore what should be done about gambling as a whole, and they actually devoted a specific section back in the late 90s generating recommendations and findings about what should be done with internet gambling. Among the reasons for prohibition cited in this report, and probably which is the reason which for the bill that you see today, has to do with access by minors to these sites. I think there's a legitimate state interest for people to be able to basically prevent minors and children from going into these internet gambling sites and placing bets. Obviously, children can't do that at bricks and mortar casinos, so why should they be able to do that on internet sites? There's also a legitimate concern about pathological gamblers and basically the whole idea of gambling as an addiction, which many people do suffer from. And also, finally, a more consumer protection oriented idea that these offshore gambling sites, if they're based solely on the internet, there's no way to enforce, perhaps if the site decides to refuse to pay winnings or manipulate the game such that you think that you're playing according to certain odds, but in fact you're not, there's really no way to protect an end user from those sorts of things. Specifically, the Commission came up with a couple of particularly relevant findings. First, it recommended that if Congress acts to prohibit internet gambling, that it also require the National Institute of Justice or other appropriate agency 12 months after the effective date of that statute to measure its effectiveness for a period of 1 year. Basically, I think this is a recognition that we're kind of in uncharted territory in terms of regulating a specific activity over the internet. Of course, the more relevant recommendation, and I'll read from it in part, is a recommendation that the federal government should prohibit, without allowing new exemptions, internet gambling not already authorized within the United States or among parties in the United States and any foreign jurisdiction, with the further recommendation that the President and Congress direct the Department of Justice to develop enforcement strategies that included, but are not limited to, internet service providers, credit card providers, money transfer agencies, makers of wireless communication systems, and others who intentionally or unintentionally facilitate internet gambling transactions. I think that's probably a lot about what we're here to discuss today. Now I'll read briefly from what I think is the operative language of the bill that I just told you was passed. And I'm starting from section 5363 in case you're interested. It states that no person engaged in the business of betting or wagering may knowingly accept in connection with the participation of another person in unlawful internet gambling, credit, proceeds of credit, electronic fund transfers, checks, drafts, or similar instruments, or other proceeds of any other form of financial transactions. And the rest of most of the rest of the portion of that section is dedicated to basically directing the Secretary and the Board of the Federal Reserve to actually come up with these policies to basically force the banks and other financial institutions to identify and to flag basically any of these questionable transactions, and then to basically refuse to transact those. There's also civil remedies to allow attorneys general of the various states to enforce their own particular rules, and also there's a criminal provision such that if you violate this title, you may be fined and imprisoned for not more than 5 years. So that's basically the overall impetus of the text. Let's see. I guess I'll leave any further interpretation to the distinguished panelists. Finally, I'll just leave it with a quote also from the commission that generated this report. And this is basically an overall quote recognizing that this is sort of new territory. It says, to say that gambling has grown and taken shape in obeisance to government decisions does not imply that there was a well thought out overall plan. All too commonly, actual results have diverged from stated intentions, at times completely surprising decision makers. There are many reasons for this awkward fact. So I guess without further ado, to discuss the benefits and the burdens and possibly the inefficiencies of this bill, I'll start with Steve Verdier, who is Senior Vice President and Director of the Congressional Relations Group for the Independent Community Bankers of America.
Well, thank you very much, and thank you all for being here. I was thinking that perhaps this should have been held on Halloween rather than tonight for this reason. Our members, our 5,000 members, plus really all the banks and financial institutions in the country are heavily involved in the payment system, and you'll learn more about the payment system than anybody really needs to know this evening, unfortunately. This bill had the potential, I don't think it will the way it's written, but I think this bill in earlier versions had the potential to really disrupt the payment system. We're talking about 36 billion checks every year, at least as of 2004, and 12 billion electronic transactions in the same year. I think the number of checks has gone down, the number of electronic transactions have gone up, but I think the net amount is probably the same, probably much more. But the reason it was scary is that a lot of times we deal with issues that potentially put a burden on the nation's banks, and that's just kind of goes with the territory. But here we had a moral issue, if you will. A lot of people thought that what was going on here was was wrong, was morally wrong for people to be gambling on the internet. And that's pretty tough to say, well, this is going to be a burden on the financial system. But, well, no burden should be, so great, I think, in some people's minds that it shouldn't be borne. But we decided to take up the cudgel anyway. This bill had been kicking around quite a while. The reason it passed this year is because of Jack Abramoff. He took credit for killing an earlier version, and the members of Congress decided that one way to kind of get right to get on the right side of the scandal issue was to pass this bill. It had always been killed previously by the gambling lobbies. They never really got out of the shadows, but they were able to kill the bill, particularly in the Senate. And of course, the problem between the House Banking Committee and House Judiciary Committee also conspired to make it hard to pass. House Financial Services Committee went ahead and passed the bill without a hearing this year, and there was some process behind the scenes. We were able to get some things done, but the Judiciary Committee also took jurisdiction over the issue, and we were able to get a witness before that committee and explain the problems that community banks and everybody else would have about this. And this is your lesson on the payment system. We talk about the nation's payment system, and the question is, well, what in the heck does that mean? Everybody in this room uses the payment system probably 3 or 4 or 5 times a day. If you have a credit card, you make a payment. That's one part of the system. If you write a check, that's another part of the system. If somebody takes that check and puts it in front of a scanner and turns it into an electronic blip that goes against your checking account, that's what's called an ACH transaction, electronic transaction. And those transactions go through very, very quickly. You can't imagine what goes on behind the scenes when somebody swipes that credit card. There's an awful lot of work going on at the computers at Visa and MasterCard when that happens. And it's kind of like the water company. If it works, you don't have to know about it. Nobody should have to bother. If you had to worry about the water company all the time, you'd drive yourself crazy. But there are critical differences between the systems and what they can do. If the idea is to track illegal internet gambling transactions, the credit card operations have a way of tracking the merchants or the recipients of payments. They have that system because there's a credit risk involved. They're taking a risk when they make a payment to a grocery store, a liquor store, an internet gambling store, a pornographic site of some sort that may be legal. They're taking a risk. There's more risk the further down the spectrum you go. And so each type of merchant has a particular code. And so if there's an internet gambling code that's out there, and there is, the credit card operations can just block payments to those sites. And as a matter of fact, they've been blocking payments to those sites for several years. So this bill really just tells them to do what they were already doing. And that works. There's a finite number of those, of merchants. A lot of merchants, but there's a finite number. In terms of payments made with the checking account system and the ACH system, everybody on the planet with a bank account is a potential recipient of a check or an electronic payment. So tracking and blocking those would be quite a task, and the technology isn't there. When you make a bank clears an electronic transaction or a check, all they really have, the only information they have about that payee is the bank account number and the bank's own number. Each bank has a unique number. So there isn't any information about the type of recipient that you have. And so there are regulations under this bill, and what they say is if it's not reasonably practical or feasible to track and block these transactions, the Treasury and the Federal Reserve shall exempt. In the House language, it was shall consider exempting, and we thought that they ought to do. If they can't do it, they ought to just flat exempt. And we worked very closely with the Senate folks, not as closely as I would like, but we did work with them on that language, and they dropped the word consider. And so we've got a pretty strong directive to the Fed and the Treasury. Don't disrupt the nation's payment system. Don't stop you from using your checking account or electronic transactions. An unanswered question is there some midpoint between a complete tracking and blocking system and just a full exemption? We'll have to find out about that. A couple of other tricky items. There's a requirement in the new language, the latest language, that says that regulations should protect transactions that are gambling transactions that are legal. In other words, the regulations are supposed to say, block the illegal ones, but you got to let the good ones go through. We don't know how they're going to do that, and it flatly contradicts other language that had been earlier in the bill, or in earlier versions of the bill, that says that financial institution overblocks transactions, blocks legal transactions. They're protected from liability. So they don't have a lawsuit risk, but is there a regulatory risk that financial institutions have? Darn if I know. Lawyers smarter than me are kind of puzzled by that apparent contradiction. But some of the good news that the business of betting or wagering is not included as part of a financial transaction. And the other thing that gives us quite a bit of comfort is the regulations that apply to financial institutions are going to be the sole way that we're going to be asked to comply, we hope. Court injunctions are not to apply against financial transaction providers under this legislation. Now, what we're worried about is if some clever prosecutor, and they're all pretty clever, I suppose, will come up with something outside of the bill to use as an excuse for an injunction, and so then we'll have a federal judge who is probably not an expert on the payment system, probably knows less about the payment system than you all now know, might be enforcing and directing that the entire payment system of the United States be transformed so we can track and block these transactions. So like I say, very scary for the entire financial services industry. We think we've got language that is reasonably protective, but it was a long, hard slog getting it done, but I think we were reasonably successful.
Thanks, Steve. Next we have Kaman Shadab, who is a senior research fellow at Mercatus Center, and specifically in the regulatory studies program.
Thank you very much. Thank you all for coming. Anytime the government regulates market activity, it's always an uncertain question how the market participants are going to react in response to the regulation. And that's even more the case when the regulation itself introduces uncertainty into how to comply with it and how market participants are going to react in general. Now, this legislation and the regulations that are going to be promulgated pursuant to it introduce some uncertainty. And so here it's interesting to note how the financial institutions, the gambling companies, and the gamblers are going to be reacting to the legislation. So first, to understand the rules a little bit, let's quickly just go over what it does and what it doesn't do. As been stated previously, what the legislation does, what the two primary rules of the legislation do, are to prohibit gambling companies from accepting funds from American bettors in violation of U.S. gaming law. And the second and the real meat of the legislation is that it requires financial institutions to block, identify, or otherwise prevent or prohibit those type of illegal transactions from going through. In other words, banks, credit card companies can't send those transactions to gaming companies in violation of U.S. law. Now, credit card companies, as was already said, already prohibit those type of transactions. It's easy for them to identify who are the gambling merchants and simply disallow them to be used with their credit cards. And that's been going on.
It's not easy, but it's possible for them to try.
There's a code 7995, I believe, which the credit card use. So it's
And they've got to make sure that the illegal internet gambling site actually uses that code instead of one for a grocery store.
Right, that's true. That's assuming the merchant actually complies with that. Yeah, exactly. And in any case, it's much easier to identify for credit card than it is for banks. And I just want to look at a couple quick provisions of the rule and then see what uncertainty it creates, what market participants have been doing, and what are the potential outcomes, in particular with third-party offshore banking or financial or e-wallet institutions like PayPal, which is an American one. Okay. So 9 months or 270 days from when the bill was passed, the Secretary of the Treasury, the Board of the Federal Reserve, in consultation with the Attorney General, have to promulgate regulations telling banks and other financial institutions how they can go about identifying, blocking, prohibiting, or otherwise preventing their businesses from being used to send funds to unlawful gaming sites. And they can do that either simply by identifying and blocking or choosing their own method of prohibiting. And the regulations are going to come down. They should give examples of how to do that. They should give some guidance, and they should allow the financial institutions, according to statutes, some leeway and some methods to choose between them. And as also said earlier, the financial institutions can exempt compliance with the law to the extent that it is impractical, and it probably will be impractical for paper checks and what have you, and electronic funds transfers to have to go through each separate transaction and identify who the payee is. And also what the statute does, it creates no liability for overblocking, as long as it's done on a reasonable basis. So if a bank blocks a transaction which was not going towards a gambling site, they cannot be sued under this law because so long as it's done under some reasonable manner. And the issue there is if the bank, it gives an incentive for banks not to be completely diligent in working out these transactions, knowing they have a shield from liability. And the problem there is it creates at least a slight bit, or at the margin, of legal uncertainty to the extent that financial transactions are not going to be processed in the way they should be processed. They would be blocked for some unreason. For example, there might be merchants that call themselves party poker or party gaming or something that have nothing to do with gambling, but the banks just start blocking them because they have a legal basis to do so, obviously based upon the name of the merchant. Okay. And one other provision of the statute is somewhat curious, at least to myself, is that it limits enforcement against financial transaction providers to the extent they are acting as financial transaction providers. That would seem to limit enforcement of injunctions, temporary restraining orders, or what have you against institutions to the extent they are acting solely as banks or other financial intermediaries. But that could also cause a very large loophole in the very law itself because it applies to financial transaction intermediaries, which would include, by some, if you stretch that definition, credit cards, banks, and other types of institutions like that. So, what's the upshot of all this? Well, the implication is that this law is unlikely to have an effect on some of the major players, at least in the long run. This law does not apply to gamblers. It doesn't create any new illegal types of gambling. It doesn't, in fact, change any substantive rule of gambling. What it does is, like the title says, just changes the enforcement, how the gambling laws, which are already on the books, although they are subject to much disagreement about what is actually illegal internet gambling. It's just basically a method of enforcing those laws. And as I said earlier, banks will likely get exempted in ways that would hurt them from having to go through the checks. And credit card companies are already blocked, or to a large extent, gambling transactions. So the law is somewhat redundant as applied to them. And there's a chance that the law also might not apply to poker to the extent that poker players can successfully argue in a court that playing poker is predominantly a game of skill and not a game of chance. Because under many state laws, if you can argue that if gambling law will not apply to a game that's primarily a skill as opposed to a game that's primarily a chance, be betting, like roulette, lotteries, and things like that. Okay, now the two big problems for enforcement of this law is that the United States has no jurisdiction over foreign entities operating illegally, foreign businesses to exercise jurisdiction and prohibit them from doing what is legal in their countries through either injunctions, court orders, or fines, or what have you. So one thing that's important to realize from there is that given the economics of the industry as it is today, prior to this bill being passed, is that most if not all gambling companies are offshore. They're not United States entities at all. So this law has nothing to say about them. It does not apply to them directly at all. And the United States cannot seek enforcement or injunctions against a company that's operating legally in Europe, for example, or in the Cayman Islands or the Isle of Man. Now, most importantly, the U.S. has no jurisdiction to prohibit offshore financial institutions like banks or offshore e-wallet or digital wallet companies like a foreign version of PayPal from operating for the very same reason. It's simply a jurisdictional issue. Now, why that matters is because one of the primary ways gamblers currently fund their accounts in the offshore gaming companies' websites is by using a third-party offshore gaming provider like NetTeller. NetTeller is the biggest one. And what NetTeller is a company that's located in the Isle of Man, not subject to U.S. jurisdiction, operating completely legally over there. And what it does is it takes payments from U.S. residents, and once your money is in a NetTeller account, you can use the money and the funds from there to purchase gambling services or a wide variety of goods and services around the world, not just gambling. So the U.S. has no direct jurisdiction over those types of transactions. So to some extent, the law, to take a step back, doesn't matter at all because people can just start moving funds into third-party offshore accounts and fund their gambling through there. Although there is a slight wrinkle, and there are some ways U.S. regulations and regulators might be able to get to those entities also. But two other statutory reasons why they could not would be limitations on enforcement for financial transaction providers, which I already mentioned, which could be interpreted to apply directly to the offshore providers. And also Section 5362, which of the Act, which says that a bank or other insured depository institution, by putting money in there, does not constitute a bet or wager. So basically, by putting money into a third-party offshore account, I'm not making a bet. That act in itself is not a bet, so that's not prohibited under this act. It's not considered a restricted transaction. Okay. On the other hand, though, there's some leeway for regulators to come in and stop those third-party processing transactions from coming to the fore. And again, that's important because that seems to be, post this statute, the primary way in which people are going to effectuate gambling transactions. And the basic idea there is that you can't do indirectly. The law prohibits you from doing directly. Okay, so let's just say a company starts up and it's called Offshore Gambling Wallet LLC or something. Well, the government might not be too happy about banks having their customers deposit money into this offshore wallet company, digital wallet company, whose sole purpose is to fund gambling, which would otherwise not be legal in the United States. So the regulators can simply pass a blacklist telling United States financial institutions, which are certainly under their jurisdiction, from putting money into those accounts. But the problem with companies that are not obviously used solely for gambling is that, for example, e-wallet and those other companies, you can use the funds in those accounts to buy other goods and services. And furthermore, some of those e-wallet companies, they route their transactions through third-party offshore banks. So even if the only reason you're using this third-party account or its sole purpose is to facilitate gambling, which would not be legal in the United States, a bank in the United States might never know that because all they see from their end is another bank on the other side. So there could be layers of banks or third parties or financial intermediaries, which make the enforcement problem not a big issue once basically the U.S. shores. So those are sort of where the issues play out. And some companies like NetTeller have stated that until the regulations come out in 9 months, they're going to continue to operate subject to U.S. law, but they don't know exactly what that means. There is a certain amount of regulatory uncertainty. But the second largest, or one of the largest e-wallet companies, owned by Fire1, they announced just recently that they will immediately cease to process settlement transactions originating from the United States. So there is a liability risk there. There is an exposure, that's for sure. And so they're just pulling out and not accepting any transactions from U.S. residents. And in fact, even though gaming companies that are offshore are certainly not directly subject to this law, the public ones at least have also withdrawn from U.S. markets and seen their stocks take a large hit because there is potentially some liability risk from accepting payments from U.S. customers. So that's all that I want to say now. It's just in sum that the biggest issue is whether or not individual gamblers in the United States are going to be able to fund their transactions going forward through these third-party offshore accounts. And if they are able to do that, then the law is really not going to have much to do. It's just going to change the structure of the industry and bring to the fore these third-party providers that are offshore as opposed to sort of going directly through banks or what have you. But if those transactions are somehow cut off too, then the industry will take a real big hit. American bettors will have many financial, if not legal, problems going and doing bets online. That's sort of where I see the big issue with this law.
Thank you. I just want to add a couple of things. First, possibly one of the biggest reasons why some of these companies took a large hit after the bill was passed is because right now I think there's an estimated 60% of their revenues are currently generated from the United States. That is, 60% of their business comes from here. Also, I just want to add maybe a couple of reasons why this particular statute might be particularly useful. And the first is that the predecessor statute to this, or one of these statutes which bore upon possibly internet gambling, was 18 U.S.C. 1084, which I believe the language prohibited wire transfers with respect to illegal or unlawful gambling. And there was some ambiguity there, and there was a little bit of a disconnect between some American companies who would have wanted to enter the arena of internet gambling, but could not, simply because the Attorney General had the opinion that this sort of activity was illegal and they would be prosecuted. Whereas there was basically any of the offshore sites, say in Gibraltar or Isle of Man or a few of these other places, would not be, simply because there was an ambiguity, and therefore generally, at least in the criminal provision, ambiguities, as we know, are construed against the government. And I guess finally, to add that part of the difficulties in some of these regulations is that there are some bets that are legal. This law basically had the intent of, or had the general thrust of making illegal or adding a federal crime to what was already illegal by the individual states. And there's actually a carved out exception for gambling over the internet to and from a jurisdiction where it's already legal. So for example, if a certain type of gambling is legal in Nevada and it's also legal in a particular Indian reservation somewhere else, if those two endpoints are allowing a certain type of internet gambling, then to gamble over the internet would be allowed and permissible. And that's why I guess there might be some difficulty in parsing out those particular transactions while keeping or prohibiting the transactions where there's a jurisdiction where it's illegal. And finally, I just want to add the point that this regulation also came about as a result, surprisingly, of the individual states, which brings an interesting federalism dynamic to the table. Generally, states, when they have a traditional area of enforcement, they want to keep enforcement of that. But the National Association of Attorneys General put forth a request saying we need federal regulation in this because it's too hard to regulate any kind of activities over the internet. And I guess it's up to, we're going to find out if the federal government, in fact, can do that also. I think the states met with limited success back in the mid to late 90s in attempting to enforce their own regulations against gambling on the internet. Finally, we do have Michael Gordon, who is from the Office of Congressman Jim Leach.
Thank you, and thank you for having me. I apologize first off if I'm a bit out of sorts. This has been a tough week. You might have seen that Mr. Leach was not re-elected on Tuesday. So I just got back from Iowa. It's been a difficult couple of days, but it certainly was not because of authoring this bill that he's no longer in Congress, or won't be in January. The bill's taken a couple of hits at this table so far tonight, and I'll try to take a step back and give you a bit of a background as to why we passed this bill, why this law is necessary, and why I think that some of the points that you've heard already are incorrect. For nearly a decade, many in the Congress sought to deter internet gambling. But time and again, the issue was stymied, often in ways that reflected imperfectly on the institution. While Congress failed to act, the illegal internet gambling business boomed. This year, Americans will send more than $6 billion to unregulated, offshore, online casinos, half of the $12 billion that are estimated to be bet this year worldwide. FBI and Justice Department experts have warned internet gambling sites are vulnerable to be used for money laundering, drug trafficking, and even terrorist financing. Further, these sites evade rigorous U.S.-based regulations that control gambling by minors and problem gamblers and ensure the integrity of the games. It is fundamental for a society to protect the security of its citizens. Here, it's relevant to note the testimony before Congress of Dennis Lormel, who was then chief of the FBI's Financial Crime Section. Quote, it's, "The internet gambling and online capabilities have become a haven for money laundering activities. We believe there is a huge potential for offshore sites being utilized to launder money. And there are examples of pending cases, particularly in our organized crime program, involving enterprises using these types of services as conduits for money laundering. Likewise, in a formal report, the U.S. State Department expressed a similar concern. The internet gambling operations are, they write, in essence, the functional equivalent of wholly unregulated offshore banks, with better accounts serving as bank accounts for account holders who are, in the virtual world, virtually anonymous. For these reasons, internet gambling operations are vulnerable to be used not only for money laundering, but also criminal activities, ranging from terrorist financing to tax evasion. Internet gambling's characteristics are unique. Online players can gamble 24 hours a day from their bedroom. Children can play without sufficient age verification, and betting with a credit card can undermine the player's value and perception of cash, which also leads to addiction, bankruptcy, and crime. Unlike in brick-and-mortar casinos in the United States where legal protections exist, and where there's some compensatory social benefit in jobs and tax revenues, internet gambling sites principally yield only liabilities to America and Americans. It cannot be stressed enough, from a macroeconomic perspective, there are no social benefits to internet gambling. And from a micro-family perspective, there's enormous harm that's frequently inflicted. A professor of business at the University of Illinois has called internet the crack cocaine for gamblers. There are no needle mark ceilings. There is no alcohol in the breath. You just click the mouse and lose your house. And these comments really couldn't be more apropos than they are for Greg Hogan, who is a 19-year-old sophomore at Lehigh University, class president, chaplain's assistant from Barberton, Ohio. The pastor's son gambled away $7,500 online playing Texas Hold'em and confessed to robbing a bank to try to recover his losses. His life's ruined. Internet gambling has become as much a part of the college experience as late-night study sessions, rooting for the football team. Researchers have called it addictive. Players attest to becoming obsessed with it. The activity is legal, but the law was not being enforced. Never before has it been so easy to lose so much money so quickly, and at such a young age. Internet casinos are proliferating, and soon, had we not acted, they would have become ubiquitous. In the next 5 years, had Congress not acted to enforce the laws banning internet gambling, and had internet casinos business plans come to pass, gamblers would have been able to place bets not just from their home computers, but also from their cell phones while they were waiting in line for the movies, their BlackBerries while they were sitting in traffic. It would have been absolutely ubiquitous. Now, Mr. Leach introduced the Unlawful Internet Gambling Enforcement Act to prevent Americans from gambling. This law, in our view, creates strong tools to help federal and state governments to enforce existing gambling prohibitions. It was designed to cut the money flow from gamblers to internet gambling sites. Specifically, the bill enhances criminal penalties for gambling businesses settling internet wagers, financial instruments such as credit cards, and it also requires payment systems to establish procedures for blocking these transactions. We've heard about the jurisdictional issue, and I want to take a moment just to comment on this. There were two approaches. One that was offered by Mr. Leach, which is a financial transaction approach, an enforcement approach. How do you deal with casinos that are located offshore outside the reach of the Justice Department? You can't arrest a casino operator who lives overseas and has all of their assets offshore. There are no injunctions that you can reach these people. What they're doing is they are breaking the law. The 1961 Wire Wager Act is clear in our view. Internet gambling is illegal. Whether it's poker, sports betting, roulette, or craps, you can't bet online. That's been the interpretation of the Justice Department of the Clinton administration, and it's continued in the Justice Department today. Now, Bob Goodlatte offered a different approach. He's a congressman from Virginia, and he believed the best way to enforce the internet gambling laws was through a definitional method, and changing the definitions of the Wire Act to make it absolutely clear what's legal and what's not. Make it clear which games are included. We supported this included. But from a political perspective, it became extraordinarily difficult. We can talk about that later. We ultimately were only able to pass this bill because we had the acquiescence of the banking community, in some ways the gambling community, Indian reservations, the horse tracks, the dog tracks, the highlight courses, the family groups, the sports leagues, the NCAA, every major sports league. And this was sort of a lobbyist's dream and a staffer's nightmare. And that every time you corrected a problem, another one popped up. And every time you maybe made a concession to one group, another group needed something too. And so it was extraordinarily difficult to pass this bill. It largely was because I think we finally were able to thread the needle. And that included, or that didn't happen to include, a definitional approach to the Wire Act. We can go into this later if you have questions or want to hear more about it. But this measure was supported by the NCAA, all of the major sports organizations, financial services industry. Steve's group, the ICBA, was the lone wolf really fighting against this bill for years. But family groups, religious organizations, and 48 of the 50 states' attorneys general, and the Association of District Attorneys, it was broad support. Now, the reason the sports groups supported this legislation is that they were concerned with the integrity of their games. The $12 billion industry in the internet casinos, you had a valuation for some of these casinos that were traded in the British Stock Exchange, that one company could have bought every single team in the NFL based on their paper valuation. Now, the temptation there is just too great. Players in the sports, we watch football every Sunday. We watch college games on Saturday because we believe that the outcome is determined by people. First commissioner in sports was ever appointed in response to the Chicago Black Sox scandal, where they fixed the World Series. So this was an existential question in many respects for the sports leagues. They fought so hard to pass this bill because you need to ensure the integrity of the games. And these casinos were operating in an unregulated way. There was no way to control their behavior. Now, family groups supported this bill as well. And it's certainly not a subject that's touched upon, as Mr. Leach said on the House floor, in the Quran, the Old and the New Testament, or the Bhagavad Gita. But the pastoral function is one of dealing with families and difficulties, and the religious leaders of all denominations and faiths are seeing gambling difficulties erode family values. Finally, the reason why the Justice Department and state attorneys general support restraints on internet gambling relates to the challenges of law enforcement, both for gambling and non-gambling activities. Because as I've said earlier, internet gambling was too easy. It was just too easy to be used by narco-traffickers, terrorists to launder money. And whenever an area of activity is lawless, it has a tendency to spin out of control. Now, it's been suggested that there shouldn't be any call to rein in activities of individual choice. But it should also be clear that in the history of the Western world, wherever gambling has been legalized, it has been subject to careful regulation. And that's simply not the case with the internet. Nor is it the case that an individual's misjudgments do not affect society as a whole. There is nothing in internet gambling that adds to the GDP or makes America more competitive. Indeed, if an individual can't repay his or her credit card debts, neighbors are subject to higher interest rates. It affects us all. Everyone loses if this industry continues its remarkable growth trends. Entertainment's multidimensional, but gambling and gambling online is not the same as bowling. There's no home, no office, and no college dormitory should be a casino. And American law varies by state, but generally makes no moral judgments on the wisdom of gambling. The law, and as a caveat, I've been a gambler all my life. I grew up in Los Angeles and have gone to casinos for years and years. I have no moral problem with gambling. Internet gambling is something that is so unique, and it's a problem that is growing and is becoming so big. If we didn't deal with it, it was going to only spiral out of control. And the fact that we didn't deal with it 10 years ago, when the internet boom really happened, it was something that needed to be remedied. It was something that needed to be fixed. We let this Congress by failing to act, let this industry grow. And they finally have acted to prevent it. So I'm happy to answer any questions you have. But finally, it should be stressed one last time. that internet gambling was never legal. And in a country where the rule of law is the cornerstone of our society, where upholding the law is fundamental, we finally needed to add, we finally needed to enforce this, because if we didn't, it had potential to really undermine everything.
Thank you. I guess at this point we can open it up to some questions.